So it should give you a notification that we are recording. So go ahead and accept that. As long as you stay on mute, it should not pull you. All right. So thank you all so much for coming. We're happy to see all of you, and I see a lot of new names in the crowd. So my name is Vijaya Singh. I am the landlord tenant staff attorney here at VIP. I started here last January remotely, of course, and I'm now getting used to the office. We're back in the office a little bit, which is wonderful. With me presenting will be Iman, who can introduce herself. Okay.
Hi everyone. Yes, my name is Iman Abawada, and I'm the current AmeriCorps Vista Landlord Tenant Outreach Coordinator at Philadelphia VIP. I recently started about 3 months ago, so you won't hear my voice too much during the presentation. I'll pop in for a few moments where I feel the most comfortable, but I'm really happy to be here, and I'm happy that everyone is taking their time out for this training, and hopefully it'll be a worthwhile use of your time. Thank you all.
All right. As I mentioned, we are recording this, so as long as you stay on mute, you should be good to go. If you have any questions, feel free to drop them in the chat. We'll also have a question and answer portion towards the end where we'll turn off the recording and allow you guys to unmute and feel free to ask in person. Okay, so we'll jump right in. So just a brief intro to VIP. We leverage the powerful resources of the community to provide quality, volunteer legal services and ensure access to justice for low-income Philadelphians. You, our volunteers are our powerful resources. Philadelphia VIP is actually the only organization in Philadelphia that relies 100% on our volunteers to fight poverty. So a little bit about eviction in Philadelphia. Prior to the pandemic, Philadelphia had the 4th highest eviction rate among large cities, with 1 out of every 14 renters facing eviction each year. Prior to the pandemic, we were the first big city in the US. A simple Google search seems to say Cleveland has now taken that spot with the pandemic conditions and everything, but Philadelphia is still up there. Close to 26% of residents and almost a third of our city's children live in poverty, and these are pre-pandemic numbers. We don't have the current ones at the moment. So it's probably worse now. So I wanted to take a second to explain the different types of outcomes that can happen from a landlord-tenant eviction case. The case can always be withdrawn if it's worked out or dismissed. A money judgment is where the tenant owes money to the landlord according to the judge, right? Those are the kind of judgments that impact the client's credit score and credit report. So those are the ones we try to avoid the most. The judgment of possession is where the tenant has to leave the property. And it can be a combination of both or one or the other at the end of the case. So without representation, tenants often find themselves forced into repayment agreements that they can't keep up with, or they're forced to leave their homes because they weren't able to negotiate an extended period of time in the home, especially now during these times of uncertainty and fear. Tenants in Philadelphia are dealing with health and public safety concerns for their families, and they're afraid to leave their homes for anything but the necessities. And that puts them in an inferior negotiating position with the landlord. These tenants need your representation to stay safe in their homes and try to negotiate with the landlords to either reduce the amount of rent owed, get necessary repairs, or at least get an extended period of time in the property so they can find another place to live. So this chart was taken by the reinvestment fund, a random sample of 200 tenants facing eviction. As you can see, 81.8% of those ended up in both a possession and a money judgment. The judgment for possession could be satisfied through payment of the amounts owed in 78.7%. 40% of those ended up in a payment plan. 23% ended up in a one-time payment. However, a lot of those payment plans were ones they couldn't keep up with, so the judgment ended up staying on the record. Only 17.1% ended up with possession only, and of that percentage, only around 11% had 4 or more weeks to leave. 6% had less than that. However, when the tenant does have an attorney helping them out, the numbers change pretty significantly. Now only 44% of tenants end up with both the possession and money judgment. Of that, 80.8% of the judgment for possessions can be satisfied. And more of them get the payment plan. Less of them have that one-time lump sum payment, and they're able to negotiate. They're able to negotiate payment plans that they can actually keep up with, so they're able to get those judgments more satisfied. And as you can see, for possession only, it's now 51.8%, and a much higher percentage, 39.2%, get 4 or more weeks to leave. Even if they get less than that 4 weeks to leave, they're still getting more. They're getting a better agreement than they can usually move out sooner in return for forgiveness of any rent that's been owed. Our training manual is on our website. I apologize, I did not update that final slide. The picture, the updated one was posted this morning. I also separated out the checklist for defenses, which is a part of the manual, as well as some new defenses that have come up recently. I'll ask Iman to drop those links in the chat for you guys so you can see them. Otherwise, they are in our resource library on our website. So we'll jump into the landlord-tenant issues and defenses. So the statutory compliance issues are the ones that come up most often. It's usually the housing inspection license or rental license, the certificate of rental suitability for CRS, and the lead paint ordinance. So every landlord in Philadelphia is required to have a valid rental license in order to legally collect rent. With the certificate of rental suitability, it's a document from Philadelphia's Licenses and Inspections Department that just says the property is free of any open L&I violations. The certificate of rental suitability is usually valid for 60 days. It's supposed to be provided to the tenant at the beginning of the lease. And then as long as it's provided within that 60-day validity period, that's the only time it has to be presented to the tenant. It doesn't have to be renewed. It doesn't have to be provided again. Whereas the rental license has to constantly be renewed every year. And the lead paint ordinance we'll talk about in a second. As I mentioned, with the rental license, the landlord is actually required to file the rental license with the complaint for all periods of rent that they're suing for. If there is no rental license for any of the months they're suing for, they are not entitled to any rent. The judge will not give it to them. Sadly, though, if the tenant has already paid the rent for those months where there wasn't a valid rental license, there's no opportunity for them to get reimbursed or sue the landlord for that money again. With the certificate of rental suitability, as I mentioned, it has to be delivered to the tenant with a Partners for Good Housing handbook, which just kind of talks about fire code violations and things like that. The landlord cannot collect any rent for any period the landlord did not deliver that certificate. So any period prior to the delivery of that certificate to the tenant, they aren't entitled to rent for. As long as it's been delivered to the tenant, the landlord is good to collect rent under the CRS. It must be signed by the landlord, and similar to the rental license, the tenant cannot sue for any rent already paid, even if there wasn't a certificate of rental suitability provided. You'd be surprised how many cases come up where these are the issues, and they're like quick and easy to spot and argue. The court will actually look for these upon the initial filing of the complaint. And if there are any months where there wasn't a valid rental license or certificate of rental suitability, the court will actually note that. And this notice of non-compliance will be generated. It'll say there either wasn't a rental license provided, there wasn't a CRS provided, or it'll actually specify which months were not included in the rental license or which months were prior to the delivery of the certificate of rental suitability. So it took a lot of tenant advocacy to get the court to do this in the first place, but now they do. It's still a good idea to always double check the case file that we send you with the court documents, because sometimes the court will miss it, and even though there isn't a valid rental license or certificate of rental suitability, this notice doesn't get generated. So with the lead safe certification, it only applies to buildings built prior to 1978. As long as the building was built prior to March 1978, the landlord is required to provide a lead disclosure at the beginning of the tenancy, just saying that, listen, this building was built prior to March 1978. There may or may not be lead in the property. I am not aware of anything like that. Tenant has the option of having the place inspected at their own cost. However, if there is a child age 6 or under living in the property that the landlord is aware of, then the landlord is required to have that inspection done at the landlord's cost and provide the tenant with a lead safe or lead free certification. If the certification has not been provided, it can be used as a defense against amounts being sued for to try and bring that amount down, or the tenant can actually file a separate small claims action for reimbursement for any rent that was paid when this lead safe certification should have been provided to them. The eviction court, for whatever reason, it's been determined doesn't have jurisdiction over these lead claims, so it can't be filed as a counterclaim. It has to be a separate small claims action. But once that small claims action is filed and the landlord has been served, if there's enough time before the eviction hearing, you can ask for the two cases to be consolidated and heard together. So you won't have to have two separate court dates. Again, there is a right to refund for the lead safe certification issue. If the landlord doesn't provide it, they're not entitled to rent payment and they can't evict either. There is a fairly new bed law in Philadelphia. It took effect October 2020. Basically, the landlord has to provide the safe certifications for new or renewed leases, regardless of whether a child at or under 6 years old lives in the property for these zip codes as of the lead safe certifications now last up to 4 years. Lead free certifications, they don't expire. So whenever they had them done, if it was 2014, it was 2019, they won't expire, but lead safe certifications will expire after 4 years. It used to be only good for 2 years, but this new law actually extended their expiration. An additional set of zip codes will be added to the law within April 2022, at which point the entire city should be covered by it. They rolled it out in, I think, 4 different sections. The first was October 2020, and there was April 2021, October 2021, and then this last set, April 2022. You can check the website for the most updated list of the zip codes. These are updated as of this month, so they all should be there. Again, no lead certificate, no eviction, no rent. So the next biggest issue that comes up is the implied warranty habitability. This warranty was established in PUV homes, and it cannot be waived. This warranty is the tenant has an obligation to pay rent in return for the landlord providing and maintaining a habitable or safe, sanitary, and fit premises. If the landlord breaks this obligation, either doesn't provide a habitable property or fails to maintain it, the tenant is relieved of paying that rent. This cannot be waived in the lease. You'll see some leases will say that the tenant is responsible for making all repairs to the property and maintaining the property. That's void. It can't be upheld in court. The tenant can be responsible for the minor stuff, but when it comes to foundational issues, holes in the wall, things like that, the landlord does actually have to fix those. If there's a habitability issue, it's good to create a chart which lists what repair issues there are, if any rent was withheld and why, and between what period that amount was withheld. Every habitability issue or repair issue that comes up is usually worth a certain percentage of the rent. For example, in the winter months, it's illegal for the landlord not to provide proper heating. So if there's no heat in the property in the winter months, that's effectively 100% of the rent would not be due to the landlord until they provide proper heat during the winter months. If there's like a small leak or something, it may not be worth as much. It might be, $100 worth of the rent. So if the tenant is withholding any money from the rent, they want to make sure they notify the landlord that they're withholding, how much they'll be withholding, and make sure they keep it saved somewhere, because if they end up in court, you want to make sure that they have it to show the judge. Like, I have the money I withheld. If you tell me I owe all of it, then I can just send it to the landlord right now, versus, well, I had to use it for something else. The judges will not look kindly on that. And they may determine, and the judge may determine that, maybe the tenant withheld too much rent for the particular issue they were withholding for. If there are open L&I violations, that will always support the breach of the implied warranty of habitability. Photos of the issues are great. We will collect most of these for you in the case file. So usually we're compiling everything for you, or at least the tenant knows that they're supposed to get all these things to you as soon as they hear from you. You can bring counterclaims. for breach of the implied warranty of habitability. If you're suing for more than $2,000, it has to be filed as a counterclaim at least 10 days before the hearing and served on the opposing party or opposing counsel by day 7 before the hearing. Because these cases tend to come to us a little bit late, there's a good chance by the time we get you the case or you take the case from us, there won't be enough time to file a counterclaim. However, you can bring an oral counterclaim at the bar of the court for up to $2,000. So when you get to court, if there's a reason to make a counterclaim, you can still make that oral counterclaim for $2,000. This is the licenses and inspections website property history page. It'll show you, it'll list the business licenses, the rental license is usually listed under there. And then the violations at the bottom, you can open that and it'll show you any current open violations by date. And you can click through those and see if there are any open ones to help your case. And then we will talk a little bit about the lease, and I believe Iman is going to jump in here.
Yes, I can jump in now. So the lease is a really important document that we need to pay attention to the fine print of. It's basically the contract between the tenant and the landlord. So when we are looking at the lease, some of the questions we want to ask ourselves, especially regarding the term of the lease, is it a month-to-month lease or year-to-year? Are there any notices that have been waived in the lease? Are there, if the landlord is suing for utilities or attorney fees or court costs, we want to make sure that is given in the lease as well. What are the breaches of the lease? And also, is it an oral lease or a written lease? So these are some important questions we need to ask ourselves. Additionally, we'll go into the next defense that we usually see, which is a good cause. So we can go there. Thank you, Vijaya. So a defense that we see that is very important is something we call the good cause. And so this just means that if a landlord wants to terminate a lease that is less than 1 year long, the landlord needs to provide a good cause reason for doing so, and also provide a notice to the tenant that they are terminating the lease. Some of the reasons that can be good cause reasons are, for example, if the landlord has a family member who wants to move in to the unit, or if the tenant has caused, damages to the unit as well, that could be also a good cause. Or even habitual non-payment of rent or late payment is also a good cause reason as well. Another defense that we will see in our cases is something called an illegal lockout or self-help eviction. So this is important because the tenant has the right to sue the landlord for damages up to $2,000 if they experience an instance of an illegal lockout. This can look like if the landlord is not going through a court process, but changes the locks to the home, it is an illegal lockout. If the landlord blocks entryway to the home or the doors, or is shutting off utilities, like shutting off your lights or your water, that counts as an illegal lockout. So subsequent violations are considered separate and damages will be awarded separately. Any agreement allowing the landlord to use illegal lockouts or self-help eviction is void, similar to implied warranty of habitability. And then tenant can terminate the lease without penalty within 30 days of an illegal lockout.
So another thing that comes up is we find the landlords will have excess security. So during the first year of the lease, the landlord is actually limited to collecting 2 months worth of rent, which they'll usually list it as either security deposit and last month's rent, because if they collect first month's rent, that's usually applied to the first month. Other times they'll list it as just security deposit and it'll be double the amount of rent. After 1 year of a lease, however, whether it's renewed or not, only 1 month's rent may be held by the landlord in escrow to secure damages or rent. So what will happen is a lot of our cases when they come in, the tenant has been living in the property for two or more years, and the landlord still has that last month's rent in their pocket, even though they have the security deposit or they didn't return any of the security deposit where they collected double the amount, right? It should have been applied to rent that was owed or one of the other previous months of rent. So it becomes a defense in eviction court if there's any money owed, right? The landlord has this extra money, they should apply it to what they're suing for, and therefore reducing the amount that the client has to pay back at the point of the hearing.
Some other less common defenses that don't come up too often, but we should still be aware of are two. One is just regarding the Fair Housing Commission. The other is regarding the notice to vacate. The Fair Housing Commission, or the FHC is a separate entity. It's a committee. It's not a court entity, but tenants can file complaints with the FHC if the landlord is, for example, failing to make needed repairs after the tenant has brought them up to the landlord and given them enough time to make the repairs. So if a tenant files an FHC complaint against their landlord before an eviction was filed, the eviction hearing would be continued until the FHC complaint reaches a resolution. And also the resolution can resolve the eviction as well. The other defense we would like to know is notice to vacate. So depending on the term of the lease, the notice to vacate varies in terms of giving the tenant enough notice. So if a landlord is terminating or evicting a client for non-payment of rent, then they need to give the client a 10-day notice to vacate. If the landlord is suing for termination of the lease or claiming that the tenant breached their lease, they need to provide them with a 15-day notice. And then otherwise, if the landlord is suing for eviction for a lease that is like an annual lease, then they need to provide the client with a at least 30 days notice. And the notice to vacate is something that can be waived in the lease. So in the future, we like to advise our clients not to be waiving any notices. They need to be aware of all of their rights.
It's just reminding them to read the lease. And when you review the lease, you can also see that they agreed to waive it, that they, agree to a longer period of notice. Some leases will grant longer periods of time. So with municipal court, they'll usually allow the notice to vacate as long as the period runs before the hearing. They'll still hear the case. If the period is still going, then it becomes the stronger defense. They usually just let it go. With Fair Housing Commission, just keep in mind that if the eviction complaint is filed first, then FHC can't accept anything from the tenant. The eviction hearing will have to finish first. Okay. So other less common defenses that can come up is one of retaliation, where a landlord is not allowed to retaliate against a tenant who has only properly asserted the rights of the tenant. So the landlord can't sue for eviction just because the tenant called L&I. It becomes a rather difficult defense to prove, however, because the landlord is not usually suing for just plain eviction because the tenant called L&I rather. It's usually they're usually suing for either they withheld rent or maybe they withheld too much or some other issues going on. So it's not the easiest thing to prove, and it doesn't come up too often. We usually advise clients, if you win the case, the eviction case, finish that out and then go straight to Fair Housing Commission and file a retaliation claim. Where did that just go? Sorry. For domestic violence cases, a landlord cannot evict due to incidents of domestic violence. A victim has the right to terminate the lease on 30 days written notice with documentation of the domestic violence. So in order to prove it, they do have to provide some sort of documentation, whether it's a police report or a medical note or something from the hospital. They have to be able to prove it. It's not gonna work with just their word, unfortunately. VIP cases rarely include this. As I said, I've been here since January of last year and I haven't seen it come across my desk once. So we will always let you know if it does come up, but we just want you to be aware of these other defenses in case they do. So the eviction diversion program, I don't know if a lot of you are aware of it. It kind of started up in 2020 in response to the pandemic. It is a way for the landlord and tenant to communicate prior to an eviction procedure where they can try to reach an agreement. So that way, no complaint has to be filed and they can kind of just move on with an agreement with each other, right? So as of January 10th, 2022, the mayor signed this amended eviction diversion program bill, which actually requires landlords to provide to the tenant a notice of diversion rights, which tells the client or the tenant that you have the right to participate in this mediation program to reach an agreement with your landlord before the landlord files for eviction. The notice directs the tenants to call the Save Your Home Philly hotline in order to participate. So in order to take advantage of that right, they have to call that number in order to participate, after which they'll be scheduled to meet with a housing counselor. Once they speak with the housing counselor, a mediation will be scheduled between the landlord and the tenant to try and work out an agreement. It usually takes it's supposed to take 30 days to run. And then after that, if no agreement can be reached, then the landlord can move forward with suing for eviction. Only landlords right now can apply to the program. So once the tenants call the number, then the landlord is notified that yes, your tenant wants to participate, go apply. If the landlord fails to provide this notice of diversion rights, it becomes a defense in court. The law itself does specify that it takes effect on January 1st of 2022, but the mayor didn't actually sign it until the 10th. So we're not sure how the court will deal with that just yet. So for now, we're playing it safe and just going with from January 10th on. If the complaint was filed, there should be a notice of diversion. This is an image of the notice, just so you know what you're looking for. It should be posted on the docket, and the landlords are required to prove delivery, whether it's a green ticket, certified mail, or something else. And the Emergency Housing Protection Act. So this was a law put into place in response to the pandemic again. It created a pandemic protection in Philadelphia. It allowed for the tenant to request a repayment plan With the landlord, usually lasting about 9 months or so. It waived late fees during the pandemic period, and it gave the tenant the option to ask to participate in the eviction diversion program prior, of course, to the landlord filing for eviction. The repayment plans and the request for the eviction diversion program no longer has any effect. However, it still waives late fees through September 2021. So it can still play an effect at this point. In order for the tenant to take advantage of the waiver of late fees, the tenant has to complete the certificate of hardship and provide it to the landlord for it to take effect. As I said, any late fees between March 2020 and September 2021 can be waived. If any late fees were paid during that period, it should be applied to future rent, but it's one of those things where you have to ask for that or else it's not going to happen. And then once you fill out the form, there's a presumption that the tenant experienced a COVID-19 hardship. They don't have to submit any further proof for the waiver of late fees. So municipal court, you currently have the option of appearing in person, of course, and also remotely via Zoom or telephone. However, in order to be granted a remote appearance, you will need to provide a valid reason. And those valid reasons are usually extenuating circumstances or some type of ADA accommodation request. And there's a form on the court website that you can submit. We also have it compiled together for you on our website in the resource library. The remote hearing is easy to set up. It's really just an email once you have that reason, and you include it in there with either your email address and the clients if you're doing Zoom, or your phone numbers if you're doing a phone hearing. Last we heard in January, due to the Omicron surge, the court was granting more Zoom hearings without a reason. They were just trying to reduce the number of people in the courtroom. As of last week, they were still allowing that. So there's a good chance if you put in that request now, it would still go through. And we do have quite a few cases available on our website. So in the next few weeks, so I would highly recommend taking advantage of that. The court is requiring everyone to be masked in the building, whether or not you're vaccinated, doesn't matter. Last I heard, they're still limiting the elevators to 2 people at a time. I don't know if that's changed. I kind of hope it hasn't. Okay, so after the court hearing, so our VIP volunteer attorneys for landlord-tenant cases only have to represent the court through the municipal court hearing. You're more than welcome to help the client through the appeals process if you'd like to, but you are not required to do so. I do just want to run through the appeal process because there is very short time limits. So at least you'll be able to advise the client on taking further steps, which they are able to do pro se. So if the tenant receives any type of judgment for possession, either judgment for possession or a mix of judgment, possession, and a money judgment, the tenant has 10 calendar days to file a notice of appeal in Court of Common Pleas. If it's money judgment alone, then they have 30 days to file. They can go to City Hall, the Clerk of Court's office, and be helped to get the supersedious stay if there's a judgment of possession in place. The supersedious stay, as long as they escrow money with the court, will allow them to remain in the property through the appeal hearing. and to completion. For VIP clients, they will have to escrow 1/3 of the monthly rent at the time they file the notice of appeal, 2/3 of the monthly rent 20 days after that, a full month's rent 30 days after the date of filing the appeal, and then 1 month's rent every 30 days after that. And it's a 30-day cycle, not a monthly one. So that's also something to make sure you advise the client about if they're looking to appeal. If there's a judgment for possession, in order for them to stay in the property while this appeal is going through, they have to be able to afford that supersedious stay, or else they're going to be kicked out at some point before they even get through to the appeal hearing. So you may have heard that Right to Counsel is here in Philadelphia. So for all landlord-tenant issues, are tenants facing eviction in Philadelphia, they have a right to counsel if they're facing eviction, as long as they live within 19121 and 19139. Due to limited funding, they're rolling it out. So they're starting with 2 zip codes. The law took effect in February 1st, 2022. Because we at VIP depend on our volunteers and their schedules, and we know you guys are busy, we are not currently participating in Right to Counsel at the moment because they have to be guaranteed that we'll find them rep. But if anyone is interested in getting involved with the RTC program, whether you yourself or your firm, feel free to reach out and we'll connect you with the right people. Okay, so questions. I will stop the recording to let you guys ask your questions. Give me 1 second.